Hello, everyone. So I'll be presenting on a critical analysis of the interaction between trade and gender issues. Before I begin, I'd like to thank the organizers for this opportunity. I would also like to add that I am just presenting work in progress, so it's nowhere close to completion. And I really look forward to your views and insights and comments during the conference. So first of all, I'll just do a brief introduction in which I'm just going to talk about how we can combine trade law and gender law. So we do have international conventions that deal with gender issues, such as the CEDAW. However, as all issues, gender issues cannot be viewed in isolation. But in fact, international trade law was viewed in isolation. But finally, it has started interacting with a lot of so-called non-trade values, such as environment and labor, but its interaction with gender issues was not that much. Because international trade activities were viewed as neutral, and but we should know that neutral laws are not always gender friendly because we do have affirmative action laws in our respective countries. So we should also know that trade liberalization has led to an increase in jobs for people, but a lot of it is precarious jobs, especially for women. But trade is quite intimately linked to women's economic and non-economic conditions. So why not use it for the improvement? In fact, even the WTO agreement's preamble refers to sustainable development and raising standards of living. And you have goal 5 of the Sustainable Development Goals that aims at women's empowerment and equality. So given all this, in 2017, finally in the WTO, we had the Joint Declaration on Trade and Women's Economic Empowerment on the occasion of the Buenos Aires Ministerial Conference. So these are my arguments for inclusion of gender in trade law. Now, of course, there are certain counter arguments as well. The idea that if we do include gender concerns in trade law, it might be detrimental to some women because they might have to lose employment because their employer might not be able to keep them if the employer has to provide so many rights and benefits to them. The other argument is that trade law only caters to trade, its scope should not be expanded. Then the other argument is that existing trade law is sufficient to deal with gender concerns. So, I am arguing that trade law should include gender concerns. So let's look at some suggestions that I give. These suggestions are, first of all, given in the context of the WTO and then in the context of the RTA, but they're pretty much interchangeable. So the first suggestion is, of course, to incorporate gender mainstreaming principles in the structure and mechanisms of the WTO. We can establish a committee on trade and gender to build expertise on the subject because we already have committees on trade and environment and trade and development. So why not on trade and gender? And this committee can help build expertise within the Secretariat, the dispute settlement panelists, the appellate body members, and even in the members themselves. Apart from the committee, which will also have a overseeing role, like many of the committees that we have, we can have an expert group on trade and gender within the WTO, which can provide advice to the WTO bodies and the members. So, for example, dispute settlement panelists could consult this expert group on trade and gender if need be. Then we can conduct a gender impact review of existing and new WTO agreements. It can be conducted by the WTO Secretariat. The outcome of the review will be quite helpful if later on we want to draft WTO law in favor of gender. Then we can use the existing trade policy review mechanism to examine the interaction between national trade policies and gender issues in the WTO members. We can also have more women panelists in dispute settlement panels in the appellate body and, of course, in the national missions and ministries of the members. Of course, having more women doesn't solve the problem, and that is why I talked about capacity building, which would also, I talked about building expertise, which would also include capacity building and training the persons who are in a position to take decisions. Another thing we can do is that the WTO law should not restrict national policies promoting gender equality. Now, those were some general suggestions. Let's now come to suggestions relating to the WTO law itself. So we could, for example, add provisions on, let me sneeze. Okay, it didn't happen. So we could add provisions on labor standards and social clauses in the WTO agreements. We can include provisions on gender perspectives in each of the WTO disciplines and agreements. These can then be streamlined into national policies and regional trade agreements. We can have a multilateral agreement on gender and even labor issues in the WTO. If not multilateral, let's at least have a plurilateral agreement. we can also require members to protect those who are negatively affected by liberalization, because frequently it is women. So the idea is WTO promotes liberalization, then it should promote it till the end. That is, those who are affected negatively by it should also be considered by WTO law. Then we must remember that these agreements or new provisions that we will bring in, they could be structured like the TRIPS agreement, which means that the members will be required to implement certain minimum standards. Now, the other thing is that when we actually get down to enforcing these laws, if we actually have them, then what should this enforcement look like? Well, it can target the individual violators and not the states, that is the member states of WTO, because then it would just be targeting the innocent population, which includes the women. Now, this is going to be really difficult in the WTO context, and it would require a change in WTO law, because this means that member A is going to file a case against member B because an individual in member B, individual or company or whatever, as in a private person, is violating gender norms. So, and this individual needs to be needs to be taken care of, as in, you could use the WTO's retaliation mechanism, but how? So we need a change there, but we should keep in mind that when we enforce these laws, we should not enforce them in such a way that innocent populations of the members suffer, because these populations would certainly include those whom we want to protect, in this case, women. Then we can also use a dispute settlement mechanism to uphold gender concerns, but then it would create dependence on panelists and adjudicators who might not be equipped to deal with gender issues. But then, as I said in the beginning, in my slide prior to this one, that we can actually train them, build capacity, and they can have access to advice from the expert group. That would be helpful. Then basically, the dispute settlement mechanism can take into account gender issues, whether or not they're incorporated in WTO law, while it is interpreting WTO law, and thus in this way, it might actually lay down a set of guidelines on the issue, which would be helpful in the future. However, currently, the results of this are not very encouraging. So we have this case on EC hormones, which was an SPS agreement case. And in this case, basically, the EC said that there's a possibility of this meat causing breast cancer to 371 women. And the appellate body said that, well, these scientific studies have not been personally conducted or supervised by the testifying expert. They do not focus specifically on the residue of hormones in the meat and the fact that this meat may cause breast cancer to 371 women, and therefore the EU's restriction, or the EC's restriction, was not upheld. So not very encouraging, but let's hope for something better. Well, so currently we don't have any WTO law on gender. What we do have is the Joint Declaration, which is not really law, and there's no binding obligations there. So what we could do is to make use of the exceptions. Of course, it's not the perfect way to go about it, but given that we don't have any law, we could make use of the exceptions. And I'm referring to Article 20A, B, and D. So basically, Article 20A and Article 14A of GATS. So Article 20A of GATT and Article 14A of GATS, they talk about public morals. So we could include gender concerns in public morals. Well, a lot of the members are already party to a lot of international conventions related to gender. So perhaps we could include it in public morals. And we do have 3 cases, US gambling, China audiovisual products, and EC seals, which say that it is up to a member to determine its public morals. The members must have certain amount of freedom to determine what constitutes moral, public morals in their society. So there is a possibility there. Then you do have Article 20B of GATT dealing with human life and health. And we have a number of cases. So here I've mentioned EC asbestos. So definitely human life and health, we include gender concerns there. Then you have Article 20D, which says that national laws not inconsistent with the GATT can be upheld. Well, measures to implement the national laws not inconsistent with GATT can be upheld. We do have cases there, I've listed here some of them, in which these national laws were not upheld, but we can have national laws promoting gender equality, which could be upheld. And of course, to do all this that I'm saying, we already have precedent, because we do have protection of the environment in US shrimps. We do have protection of public health in EC asbestos. So there is precedent. Now, since I've talked of US shrimps, I'd also like to refer to Article 31 of the Vienna Convention on the Law of Treaties. And basically, it says that the treaty should be interpreted in its context. Now, in the US shrimps case, the appellate body referred to sustainable development in the preamble of the WTO agreement. So to protect the environment, so it could be used to protect gender as well, to uphold gender issues or gender concerns. The appellate body also referred to the CITES. to say that the turtles were endangered species. So it can also refer to the sea dog, for example. However, this is all very optimistic. However, there are certain obstacles which need to be crossed. So the obstacles are, well, first of all, the word necessary. The word necessary means least trade restrictive. So if there's another option available, we would have to adopt that, which is what happened in the Thailand cigarettes case, in which Thailand said that the American cigarettes were aimed at Thai women. But the panel said that your import ban is not necessary under Article 20B to protect human life and health of your women because there are other alternatives available. So that's one. The word necessary is one obstacle. The other obstacle is that there is a chapeau to be satisfied, which talks about unjustifiable and arbitrary discrimination. It also talks we cannot have disguised restriction on international trade. Right. So that was a little bit about WTO. Now coming to what we can do in this FTA. Well, most FTAs, they do contain, many FTAs actually, especially those including Canada, they contain general or best endeavor provisions relating to general or best endeavor provisions relating to gender. So clearly they lack firm commitment. And one of the ways to move ahead and perhaps move towards firm commitment would be to include gender stakeholders while the FTA is being negotiated. So that would really reveal the extent of the concern. So that can be done. We can have a chapter on specific gender commitments in the FTA. Now, these gender commitments should be enforceable in dispute settlement of the FTA. The dispute settlement should not require consent of the parties, and the dispute settlement or this chapter on gender commitments should not be used for protectionism. Again, when we enforce, we should target the individual violators and not the innocent population of a member or party to that FTA, because that would just target those women whom we're trying to protect. Then, in fact, in each chapter of the FTA, for example, labor, investment, government procurement, we can include gender provisions as well. We can even require that all the parties of the FTA will implement gender-related conventions, especially the CEDAW. We can have provisions in the FTA which say that national policies promoting gender equality will not be restricted. We can allow the right to the parties to the FTA to reject FTI, which is not promoting gender equality. We can require the enterprises of the countries that are part of the FTA to adopt codes of conduct to protect the employees, especially women employees. We can also ensure the inclusion of interests of women employed in the informal sector. Now, for a country like India, that's very important because a large number of women are employed in the informal sector, and a large part of our labor law caters to the formal sector. So it might help to include their interests in the FTA as well. Then we can also have some cooperation activities to help the women benefit from advantages created by the FTA, for example, capacity building, skills enhancement, etc. And also to oversee the activities which I've just mentioned, and also to build some expertise, we can have a committee on trade and gender in the FTA. Of course, I understand that all this is very optimistic, and these are not foolproof guarantees of improvement in women's condition. But it's still a beginning. It's a call to seriously examine the incorporation of gender values in trade law, be it international trade law, be it in the FTA, and with the hope that members will come together to seriously consider and act on the interface of gender issues and international trade law. So that's that. That was what I wanted to say. And here are some references if they are of interest to you. Thank you very much. And I look forward to your questions and comments in the conference. Thank you so much, so very much.